Did a hard drive last week that had 431 PDF files, 98 videos, and 94 images. That was the requested discovery that I had asked for back on July the 5th. So I have not yet had a chance to review all those meetings.
And I appreciate the fact that you said I will turn on the hard drive later in the day, back in July, and you did it. Sometimes people will say, I have a hard drive now, so I appreciate that. So how much time are you asking for to review that?
Judge recommends it for a little while.
All right, Ms. Ferguson, I need a 30-day reset.
Your Honor, also, I've already filed motions on this case.
Right, just one second. Excuse me, sir. Here's the thing.
Now that's a classic defense move, the 30-day reset. Why? Because reviewing 431 PDFs, 98 videos, and 94 images isn't light work. This isn't delay for delay's sake, it's about making sure the lawyer isn't walking blind into trial. And you'll notice, the judge actually praises him for doing it by the book. Respect earns you breathing room.
Do you want your attorney to go without having reviewed anything? What he has to review is a lot for him to review. If you want your attorney to go to court blind, be surprised by whatever the state presents, you can do that. But you're not his only client. So the fact that he has all of that to review, he needs to review it to be effective for you. You may continue.
Judge, I filed 17 motions this week on this case. One is a motion to suppress. The other is a motion to reduce bond. And at the court's schedule, I'd like to schedule those early as possible.
All right. So, State, with regards to the motion for the bond reduction, have you had a chance to review that, and would you be ready to proceed on that?
Not seen that, but if I look at it, Judge, I can be prepared for it.
All right, so we may be able to take up a motion for the bond reduction today. The motion to suppress, I know the state is not going to be ready for that because I'm assuming there will be witnesses needed.
Absolutely, Judge. The judge will need, I'm sorry, the state's going to need at least a week.
All right, because I'm assuming it's not just a search warrant where I can read it and say yay or nay. So we're going to come back on September 29th. Is that good for you? All right. And then state on September 29th, if you haven't done so, you'll need to be able to tender offer on that day. And an acknowledgement of discovery will be needed to sign on that day. All right, so if y'all have a seat and if you'll confer with them on the bond, the court will hear the bond matter.
Thank you.
You're welcome. All right, the court is calling 2025 CR 004887. State versus One Alberto Martinez. Could I have parties announced for the record?
Jason, give your hand for the state, Your Honor.
Robert Featherston, Mr. Martinez.
And you are Mr. Martinez? All right, your attorney has filed a motion for a bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
Okay, now we shift from scheduling to stakes. A motion to reduce bond, that's a plea for freedom before trial. The defense is saying, Judge, my client's not dangerous, not a flight risk, let him out. But remember, this is a drug case over 400 grams, that's major league narcotics territory. The bond isn't just money, it's leverage and pressure.
Right. So according to this, your client is charged with manufacturing, delivery, controlled substance killing group 1. Over 400 grams?
That is correct, Your Honor.
Over 400 grams. The bond is currently set at $25,000. According to your motion, and you're asking for the bond to be reduced?
That's correct.
All right. Do you have any witnesses?
No one is selling Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. State your name for the record. All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, have a great concern about a family member. Who is that?
My mother went to diagnosed with cancer a week ago. And the person has been doing a lot for me. So my cases been turned over. Yeah, I mentioned the charge, but I'm pleading to the court in any way that you have to tell me. I mean, I'm willing to do anything you would say, but I am my mom's oldest son, and she doesn't deserve to die alone. But I am mentioning the charge that I would hold no contest to the court, whatever, how I can get probation, whatever position you put, whatever. Whatever.
This is
Oh.
not.
No, but I understand.
Fine for
I have
probation.
that's probably with my mother. She got cancer. That's what she stated. My mom.
Your Honor, please report, he's under a great deal of stress because of this issue with his mom. He originally started with the PR bond, and then his bonding agency asked for a bond increase as a result of some issues associated with his bond. State will probably go into more detail in that. But we're respectfully requesting that the court consider a PR bond for him. There is no violence involved in this particular case. And he'd like to be able to provide some assistance to his mom. No, that's it.
Right,
I don't really have any questions. Yes, I guess.
all right, so, does he have any fun?
This is the part that hits hard, the human side of criminal court. Forget legal jargon for a second. You've got a man fighting tears, saying his mom's dying of cancer, and he just wants to be by her side. But the court can't just run on emotion. The question becomes, does compassion outweigh the potential risk of letting him go?
Judge, I'm appointed to his stance. He is indigent, and I do not think that he has any funds that he can draw on. Considering what has now happened to his mom, which was his sole source of income prior. I don't think that he's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property to rely upon in order to get anything other than.
So what I'm gonna do then, is you're saying there's no amount of bond he can make, he needs a PR bond, is that correct?
Yes, sir.
All right, so in this case, Ms. Ferguson, have him evaluated for a PR bond, and once the evaluation is complete, have him brought back. It shouldn't take that long.
Right in the most time done at the court.
All right, so Norm, I want him evaluated for a PR bond, and then we'll place him back on the docket as soon as that's completed. It should be done by next week, hopefully.
I'm not joking, Judge.
All right, thank you. Ade? All right, yes.
Were you kind of discovering session there? Was anyone said yes? Yeah, the offer from she that was complicated. That was really helpful. I know we see all this opportunity and stuff and how it's important. I wanted to just support the how do we get the offer?
All right, so do you want a jury trial or a bench trial?
Look, I feel like I'm being coerced into something that.
Now, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once the grand jury indicts the case, which doesn't mean anything, it doesn't mean you're guilty, it's just telling what you're charged with, he gets assigned to a court. Then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So, whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a...
Boom, that's a small but powerful win for the defense. A PR bond means personal recognizance. Basically, you're released without paying, but you're still bound by trust. It's not freedom forever, it's freedom on condition. The judge's move here balances empathy with caution. Smart, measured, and fair.
Counter offer. Your attorney is technically required to give that counter offer to the state, and the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I, the judge who's sitting here, will hear whatever evidence is presented and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically and normally, this is what usually happens. The state has to prove that it happened in Bexar County. Because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date. And they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say, certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought. So, do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
I don't want to take what the state is offering me because I don't think prison is.
Here's the thing. Let me just tell you. Whatever the state is offering you, I'm not involved in what their offer is. What I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. Like, prison's not a place for me. Nobody thinks prison is a place for them. You may, once every 200 cases, have somebody who'll say, yeah, I deserve to go. But normally people don't say that. So I don't need to hear about your negotiations with the state, because ethically, I'm not supposed to hear about that.
You're not even trying to hear me. He's not even trying to hear me. That's what I wanted to do.
Okay, so state on this case with Jacob. All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss.
All right, so he wants He wants something other than what you're offering him. Are you in?
And here's where it gets real messy, the classic courtroom tension between plea bargaining and perceived pressure. The defendant says he feels railroaded, but the judge breaks it down step by step, explaining the system with surgical clarity. This moment is gold for anyone who thinks the system rushes people. It shows how judges try to slow it down and make sure no one can say, "I didn't know what was happening."
Intending to offer something other than what you've already offered?
Okay, yes. But, I'm referring, no, Judge, that's the offer.
All right, so he said he's not going to change the offer that he has made.
In fact, Judge, sorry to interrupt you.
Yeah.
That would be today only offer since,
All right. You guys not putting true.
All right.
I feel like I got an ultimatum. I feel like if I hired another lawyer, I'll have a better chance of be a drug program because hopefully, well, I'm not running from what I did. I think
I would think for don't let you go. You don't say something. Your Honor, Your Honor, are saying earlier, sometimes to think about this. I know Judge says you.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box, and then I'll bring you back up at 10:30, and you need to let the court know whether you're accepting, if you've reached an agreement or whether you're going to jury trial. Those are your options. All right. Jacob Andrade? Yes.
Sure, rather than kind of any work this was application, it's always from county. They went to the attorney, and we would have just have to go to a jury document.
All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, counsel?
And there it is. When words fail, trial speaks. The defendant doesn't like the deal, the state won't budge, and now a jury of 12 will decide the outcome. From emotional pleas to procedural precision, this courtroom reminds us that justice isn't just about truth, it's about process. So tell me, did the judge play it fair here, or was this just another day in a system built on pressure?